It's a war of attrition, and the use of secret evidence is an enormous weapon in the armoury of the state.
Horribly infects the legal system and our understandings of open justice.
They managed to produce 2 items which they said would justify them taking him back to court and revoking the bail.
Once you have a bad idea established in one jurisdiction, it's not too difficult for it to spread, so long as it benefits the government. You have an evolving culture of secrecy in British courts, and an increasing willingness by the government to withhold material that a defendant would normally be entitled to.
Secret evidence is material gathered by intelligence agencies and presented in closed court sessions.
There is evidence that the government has that people are involved in terrorism, but it can't use an open court because of the risk to national security if that evidence was revealed.
SIAC, the Special Immigration Appeals Commission, hears cases related to national security.
From when the Special Immigration Appeals Commission was established in 1997, it was the first time that there was formal use of secret evidence and special advocates.
Special advocates are lawyers appointed to represent the appellant in SIAC.
SIAC had foisted on it, really, this jurisdiction brought in by the 2001 anti-terrorist legislation following 9/11 to lock up indefinitely suspected terrorists with links to Al-Qaeda on a very low threshold of reasonable suspicion.
I was very interested in the procedure that SIAC used. The key feature of the whole system is that they're not allowed to talk to the people that they're representing. So essentially the defendant doesn't know the case against them. The special advocate does know the case against them, but isn't allowed to talk to the defendant.
It's like doing a case with 2 hands tied behind your back.
Article 5 of the European Convention on Human Rights states that the individual has the right to liberty. Article 6 states that they have the right to a fair trial.
And it seemed to me when I first came to justice that this was such a major break from the fundamental conception of the right to a fair trial and the right to a fair hearing. And also, being a barrister, it seemed to me a really major break with the traditional notion of representing someone. Because how on earth can you represent someone who you can't take instructions from?
You're on guesswork, and of course once the special advocates see the secret evidence, you can't talk to them about the case. So it's a very unjust procedure from start to finish.
SIAC is located in the basement of Field House, an immigration court in London. It's presided over by a Home Office vetted judge. There is no jury. When secret evidence is presented in court, the only people permitted to remain are the judge, the Home Office legal team, the intelligence agencies and the special advocate. Everyone else has to leave.
One of the great dangers of the special advocate system is that it seduces observers into thinking that it looks a wee bit like a court. That's a very dangerous idea, and there has to be a very frank acknowledgement that proceedings involving a special advocate determining the substantive issue in proceedings is not a fair system, full stop.
One person who knows the SIAC system well is Maaloud Sahali. He's a 34-year-old Algerian man who came to the UK seeking asylum 13 years ago. In 2003, he was arrested and accused of being part of a plot to poison London with ricin. After a lengthy trial, he was fully acquitted.
It's been now 8 years of me battling in court, in, out of court, in, out of court. And the latest one was a few months ago when I lost the appeal. It's like an endless nightmare.
There was no rising plot. Maloud should have been free to pursue his asylum case. However, the Home Office presented secret evidence against him, labelling him a threat to national security.
After the Rising case, I lived free man for 5 months, exactly 5 months. Then on the 15th of September of 2005, they picked me up, shortly after the July bombing. Tony Blair, new legacy, the game has changed.
Let no one be in any doubt, the rules of the game are changing. These issues will of course be tested in the courts. Up to now, the concern has been that orders for deportation will be struck down as contrary to Article 3 of the European Convention on Human Rights. However, the circumstances of our national security have now self-evidently changed, and we believe we can get the necessary assurances from the countries to which we will return the deportees against their being subject to torture or ill treatment contrary to Article 3.
And what's striking about the Special Immigration Appeals Commission Act in 1997 is that when Parliament was debating it, a Home Office minister gave an assurance to Parliament that they would only use secret evidence in relation to national security risk, not to safety on return. So even within SIAC, the use of secret evidence has spread.
Maloud is now facing deportation under verbal diplomatic assurances obtained from Algeria that he will not be tortured on return, the details of which are only given in closed session in SIAC.
They had like a couple of days of secret sittings, secret courts, when I had to sit out, and they just go there and I don't know what they were saying behind closed doors.
The Home Office refused an interview but sent this email. There are a limited number of UK court proceedings, including SIAC hearing control orders, that are likely to use closed material. Disclosure of closed material to the individual concerned is not in the public interest, where it would damage the interests of national security, the international relations of the UK special advocate system and disclosure procedure to provide individuals with a substantial measure of procedural justice in the difficult circumstances.
In certain circumstances, the government may describe it as a necessary evil. But let's not pretend that it's not evil, because it is profoundly damaging to our system of a fair trial.
It's all too easy for governments to hide embarrassments and wrongdoing by people who have been acting on behalf of the state. And you cover it up by saying, well, it wouldn't be in the national interest to disclose this.
We have our suspicions that it's easy for them to hide incompetence. It's easy for them to treat as evidence something that's nothing more than a hunch. That we have a bunch of men who are implicated by a man who was tortured in Algeria, and we know that. So why on earth we're even relying on that is beyond me.
Intercept evidence is evidence which comes from the interception of a telephone call or an email or a text message. And in other countries such as Canada or Australia, New Zealand, the United States, that evidence is admissible in open court. In the United Kingdom, it's against the law for that evidence to be used.
One of the problems, as I see it, with secret evidence is not only that it horribly infects the legal system and our understandings of open justice, but that once it's in, it's kind of like a virus. It's what's to prevent it from spreading elsewhere. And we actually have seen this recently here in the UK.
Maloud doesn't know the secret evidence used against him, but discovered one of the methods being used by the security services to gain information about him.
The day when they said I'm threatening our security, we called their own witnesses, which is the secret agent who was supposed to assess me. And my QC asked her a question, and she was behind curtains, and say, how did you come to this conclusion that Mr. Sihali caused threatening our security? You know what she replied? And it's on paper. She said, I googled him.
Secret evidence infiltrates every aspect of the life of the SIAC appellant, even to the point of where he lives.
There was a case where there was discussions about simply the ability of the defendant to relocate back to London because his wife is having a baby, and a lot of the material in that was withheld. Once you step away from the idea of secret evidence being justified in the name of national security, you see that it can be used in lots of different areas. So we've seen the use of special advocates and secret evidence in employment tribunals related to, for example, airport staff. Or you've seen the use of appointment of special advocates in relations to data protection or Freedom of Information Act requests.
The civil damages claim that was brought by a number of former Guantanamo prisoners against the British government for their involvement in their rendition and torture was opposed by the government on the basis that they wanted to fight it using secret evidence. Now, that's never happened in a civil case in the UK before.
Luc Vervat is a prison teacher from Belgium. In 2009, he was sacked from his job without explanation. He was simply informed by his senior employers not to return to work.
It was the 17th of August. They sent a letter just saying that I could no longer put any foot in one of the Belgian prisons for security reasons. Okay, then we asked, what are those security reasons? Well, they said, well, we cannot say that. We cannot answer this question. Why not? Well, of course, we have to explain our measure, but we don't have to explain our measure if it's about the national security, the national defense, or the public order.
Human rights lawyers fear secret evidence use is here to stay.
This is not prompt justice. This is not a recourse to courts that are dealing with the situation in a lawfully objective and managed way. It isn't. It's something else. It's a war of attrition, and the use of secret evidence is an enormous weapon in the armory of the state, and it's a weapon that it is accumulating in any kind of case it chooses.
So this is really a very dangerous phenomenon. If they accept this for me, why can't they accept this for you? Or why not for another person? That the next range will be wider, you know? It can be a journalist that they don't like, a lawyer they don't like, and etc.
In 2009, following a landmark High Court judgment, it was no longer possible to revoke bail based on secret evidence. However, for detainee Yu, this judgment has not been sufficient to reinstate his bail. He remains in prison based on no evidence. Jack was his landlord prior to detention, where he lived under 24-hour curfew when there.
There was a failed asylum seeker, a man who was going to be given bail by the courts, but he had no relatives in this country, had nowhere to go, whether I would be willing to take him in.
Detainee Yu was accused of having links to Al-Qaeda. He faced extradition to the US based on allegations made by a Canadian citizen.
Ahmed Ressam is one, who is the Canadian who was sentenced and convicted for the Millennium plot to blow up Los Angeles International Airport. Now, you know, we know that he, in exchange for a lighter sentence, agreed to provide information. And then at some point down the line withdrew his compliance and tried to withdraw a lot of the statements that he'd made, but not until all kinds of people had been implicated. So what happened with you in this country and with Ahmed Ressam was that he was going to be extradited to the US based on what Ressam had said. And I think essentially that has to call into question how worthwhile those allegations were in the first place.
Despite the withdrawal of allegations, detainee U was rearrested under the Anti-Terror Act and served with a deportation order to Algeria, based on secret evidence.
My view was that whilst I don't have any inside information as to whether Mr. Yu had or hadn't done wrong things and so on, he'd served really the equivalent, something like a 10-year prison service, you know. I wasn't aware of the whole kind of regime that was about to come into the house. Firstly, there was great restrictions on any visitors to the house. They had to be cleared by the Home Office. My computer was taken from its place and put in a large steel cabinet with new passwords and so on, a reinforced lock on the door, window locks, and he was of course electronically tagged. Mobile phones had to be switched off in the house. The Home Office had the right to enter the house at any time of the day or night, and they made that very clear when they first came here, rather intimidatory way.
In January 2009, the then Home Secretary, Jackie Smith, applied to revoke bail on suspicion that detainee U was going to abscond.
My priority is the safety of this country, and I want him removed as quickly as possible.
A detailed search of Jack's house took place.
Now this was the most bizarre search of all, really. At the end of the morning, they picked a number of my maps, which had been lying around all the time. They'd gone through them before. They'd shown no interest in them. The London buses, a map of Maidstone, which they wrongly labelled as Folkestone. The man had to go through each of them in turn saying, "Is this your property?" I said, "Why are you doing all this? You've been through all these before. You've never shown any interest in these." "Well, no, we're not answering the questions. You know, you're answering the question. And the question is this your property?" "Yes, it is, yeah." So then the next day he was arrested and taken to court, as were several others, because then it became apparent that the reason was that the Home Secretary of State for Home Affairs did believe that these men were planning an escape. Justice Mitting said, "I've only had closed evidence on behalf of one individual, and that is Mr. Yu, and I will therefore revoke his bail and he will be kept in prison." And so that was the last day that he was in the house, and he's been in prison from that day to this.
What we have, I think, with various elements of this global conspiracy coming together, they're ending up being part of a narrative that is used against people who are held in this country.
So protecting our citizens requires unprecedented cooperation from many nations as well. It took the combined efforts of several countries to break up this plot. By working together, we took dangerous terrorists off the streets. By working together, we stopped a catastrophic attack on our homeland.
Despite the High Court ruling, detainee U remains in prison because a subsequent SIAC hearing did not reinstate his bail.
So now deportation to a country where you might be tortured, but on the grounds of national security, it's now the state has gained a victory, at least for the moment, in the courts, that you can do it on no evidence at all.
A verbal agreement exists between Algeria and the UK that detainee U will not be tortured on return, but Algeria refuses to sign any documentation on this.
These countries already have a terrible reputation for torturing people. Sadly, the SIAC has said it's safe to send people back to Algeria and it's safe to send people back to Jordan because of the promises that have been received. But we don't know the details of the negotiations, and we don't know what was said.
Currently there are 12 foreign nationals from Algeria and Jordan in the UK labelled as threats to national security. They're facing deportation under the Diplomatic Assurances Programme. 11 of them are under house arrest and 1 of them is in prison. All of them have secret evidence used against them and their cases are being heard through SIAC.
We're certainly extremely concerned that we've reached the point where someone can be labelled a terrorist on the basis of secret evidence. and that there's nothing that they can do about it. They have no effective right of appeal against that determination, because of course they can't say what the court did wrong, they can't say what SIAC did wrong, because they don't know how SIAC reached that decision. SIAC can't say publicly why it thinks those men are terrorists. It can only say that they think those men are terrorists, on the basis of closed evidence. There is some open material, but anyone reading the open material, if you read the SIAC determinations, it's very difficult to see how it's anything other than a hypothesis of the security service.
The House of Lords, in their landmark judgment in, I can't even remember, 2005, said that the practice of locking people up for an indeterminate period on reasonable suspicion, and where you didn't give them, even the gist of the evidence against them because of the rules about secret evidence. And that was held by the House of Lords to be in breach of the European Convention on Human Rights.
My Lord, there have voted contents 56, not contents 117. Yeah. So
we're on a roll, you'll be sorry.
I stayed in there because I thought I could make a difference. But there then came a point when you had to balance the difference that you might make against the fact that you were giving legitimacy to a system which I regarded as odious. I resigned the day after the judgment came out.
In this country, we have a presumption of innocence, and people are, innocent until proven guilty, and proven guilty in a court of law involving a criminal trial if they're accusations of terrorism. The disturbing thing is that these are allegations of criminal conduct, the most serious criminal conduct possibly there is, and yet these people haven't had any kind of trial.
Senior legal figures welcomed the end to detention without trial. However, it heralded the beginning of control orders.
And it really does run a cart horse and a great deal of baggage through many of our historic liberties. And I think we should be worried about that. But I'm glad that we're going to revisit it, and I hope we revisit it seriously.
We're very concerned about the international impact, because we know that special advocates and control orders have already been used in New Zealand, in Canada, and in Australia, and they've been discussed in India and in Hong Kong as well. So, this is, once you have a bad idea established in one jurisdiction, it's not too difficult for it to spread, so long as it benefits the government.
Since 2005, there have been a number of legal and political debates on the issue. The discourse is evolving. The email received by the Home Office points to this. On the 6th of July 2010, as part of the package of measures on detainee issues, the Prime Minister announced a Green Paper on the use of intelligence in judicial proceedings. We'll need to address concerns about the UK's ability to protect intelligence material, including intelligence material shared by foreign partners. Ultimately, it will aim to achieve a modern legal framework that best balances and enhances the interests of justice and security.
In this country, the hurdle that we need to overcome is accepting the use of intercept evidence in courts, which most countries in the world have worked out how to do, but we obstinately won't. That's it, really.
The common law, which has been established for centuries, and the notion of habeas corpus, essentially the notion, that you are free until you've been charged and convicted, is still held. And I was shocked, as I'm sure many people have been, that we have so eroded that tradition.
Article 5 of the European Convention on Human Rights states that the individual has the right to liberty. Article 6 states that they have the right to a fair trial. Since 9/11, both of these have been compromised, but at what cost? The debate continues between those in government tasked with protecting national security and those dedicated to maintaining justice, human rights and civil liberties.